This is a very appropriate moment for us to be focused on the Supreme Court. The upcoming term, which starts in exactly 2 weeks on the first Monday in October, could be a blockbuster term with cases on gun control, reproductive rights, perhaps affirmative action. Our guest speaker, Joan Biskupic, is going to preview that term for us. And we're also going to talk about this moment when the composition of the Supreme Court has changed following an unusual set of confirmations in the United States Senate. And some serious commentators are questioning the legitimacy of the court itself. Several justices have recently felt compelled to defend the court from those criticisms. So I'm thrilled to have my friend Joan Biskupic with us to share her wealth of knowledge on this subject. Joan is a CNN legal analyst who has covered the Supreme Court for 25 years for various news organizations, including before CNN, The Washington Post, USA Today, and Reuters, where she was editor-in-charge for legal affairs. Her most recent book about the Supreme Court is The Chief, a biography of Chief Justice John Roberts. And she's also written biographies of Justices Sandra Day O'Connor, Antonin Scalia, and Sonia Sotomayor. Joan is a graduate of the Georgetown University Law Center and has been a finalist for a Pulitzer Prize in explanatory journalism. So thank you, Joan, for spending this time with us. And thanks to our audience as well. We look forward to your questions. This is an interactive session, and you can submit your questions using the Q&A function on your Zoom dashboard. We're joined as well by third-year UB Law student Markeisha Dobson, who will moderate the Q&A to share questions from the audience, including Markeisha's fellow students. Markeisha is a third-year day student who's an editor of the University of Baltimore Law Forum and president of the UB Black Law Students Association. So let's get started. Joan, 2 weeks away, you're about to launch into the busy part of your professional life as the court begins its work. What are you looking for in this new term of the Supreme Court?
Thanks, Ron, and thanks to all of you who are attending this. I love the intro, that dynamic reference with those pictures to the Supreme Court. It's more exciting than what sometimes goes on there, but it was a terrific way to introduce this whole session. I'm looking forward to a couple different things. Just in the most basic sort of human element, the justices for the first time will be together on October 4th in person in the courtroom. The last time they were together was in March of 2020 before the pandemic started, or frankly, the pandemic was already starting, but it really hit the court and Washington, D.C. and the East Coast, mid-March of last year. So I can't wait to just see what they look like. It's been, a long time, about, 18 months or so, and we haven't seen Amy Coney Barrett in the flesh yet. So looking for her. It will be such an unusual time to not have Justice Ruth Bader Ginsburg among the 9. So that will be something. So just on, as I say, a very personal human level, I'm just very eager to be back in the courtroom and to see these 9. Then substantively, Ron, I'm just really interested in who is going to control this court? Where is this court going to be at? I feel like we're on the cusp of a real change, a real sea change in American law here. And we've got some data points toward that at the end of last term as the 6-3 conservative liberal majority, really flexed its muscle. And then we had so many orders over the summer that indicated a real sense of power and muscle on the part of the conservative majority. And I want to see, does that play out? And I'm sure we'll get to a couple of the cases, but obviously things like abortion rights, gun control, public funding for religious schools, those issues will all be at the forefront.
So you mentioned the human element here, and I'm interested because you have chosen biography as a means of explaining the court. And you, as I mentioned in my introduction, you've written biographies of 4 of the justices already. Was that a conscious choice at the beginning? Did you decide this is the best way to understand the court, to look at the personalities and the histories of these individuals?
It's, I've never actually really thought about, exactly why I was drawn to biography, because it just seems so natural to me. Even in my early days of covering the Supreme Court for the Washington Post, I always liked what was known as the federal page, For any of you folks who read the Post regularly back in the day, we called it the Fed page, and it was a little bit more of a human slice of government on that page. And I loved writing about what was going on behind the scenes, some of the temperament questions, how they interacted with each other. So I had dipped my toe in the water of that early on when I was with the Washington Post. And then the more I started thinking about these justices, the more I was interested in the question of whether their own backgrounds and life experiences contributed in a serious way toward where they were, how they were ruling. So I started biting that off. And I'll tell you the moment that crystallized my first biography, and that was of Justice Sandra Day O'Connor, was when I was going through documents at the Library of Congress, the Thurgood Marshall papers, back in 1993, May of 1993. I and a couple other colleagues from the Washington Post discovered these papers, and we ended up doing a big series on these once private documents. But I found a note that Justice William Brennan had written to Thurgood Marshall that, again, gets to sort of the core of somebody's personality. And he wrote, "I would have joined you in this case, pal." He was essentially saying to his pal, Thurgood Marshall, "but Sandra forced my hand by threatening to lead the revolution." And I remember seeing that note thinking, I'd always regarded Justice O'Connor as such an important figure at the court because she was, of course, the first woman justice. And I knew she was at the center of the court when I started covering it, which was in the early 90s. But I hadn't thought of her as a real power player. And that note got me thinking about her. And I ended up, Ron, going back to her legislative archives in Arizona to see what kind of a senator. She was a state senator and state Senate majority leader in Arizona. She happened to be the first woman majority leader in any state house nationwide. And that got me into bio of her. And then from that experience writing about Sandra Day O'Connor to move into Antonin Scalia, because again, using papers, I spent a lot of time in the Ronald Reagan archive for O'Connor. And once you get to the Ronald Reagan archive, you necessarily see all the documentation of why it was Scalia who was the real manifestation of the Reagan Revolution. So one thing led to another.
And would take a step back from all that to say, how did you get to covering the Supreme Court? Because when you and I met, you were covering Congress. I was working in Congress, and you were that branch of government. What took you across the street?
Well, and I was. I sort of added the Supreme Court to my portfolio, even though I wasn't quite supposed to when I was covering Congress. I was covering the Senate Judiciary Committees. And, so I naturally have issues of law and the judiciary, especially with the nominations. And my first nomination that I covered was David Souter's in 1990. And then I did Clarence Thomas in 1991. And then, of course, Ruth Bader Ginsburg, Stephen Breyer, and on, up to Amy Coney Barrett. But I chose on my own to spend more time across the street at the Supreme Court. I was with Congressional Quarterly at the time. Some of you might have done research in Congressional Quarterly's weekly report, which is what I was writing for at the time. I think that's when I met you, Ron. I think that's what I was doing.
Yes.
And then so I was always dipping my hand in it and actually writing some reference books for CQ at the time. And then in 1992, when the Washington Post Supreme Court correspondent position came open, a couple pals over there encouraged me to apply, and I did. And it was, I think, even though I had just had mostly congressional experience at that point, because I had shown that I knew about the court and I kept writing all these pieces that looked contextually at the court, they were interested in me and I was interested in them. And I started there in September of 1992.
Well, it's great. We're all the beneficiaries of that history because you've really done a fabulous job of explaining the court and the individuals. And I want to now bring you right up to the present, where one of those individuals, Justice Stephen Breyer, is the subject of much news. He hasn't been such a prominent figure to lay people, but now he is. Tremendous pressure on him to retire. He's 83 years old. President Biden would be in a position to name his replacement, but he hasn't retired. And you really had a scoop, as you journalists say, in talking to him about his thinking. Why don't you tell us how that came about and what he told you?
Sure. Back in the spring, so many people were wondering if he was going to step down. And especially after Georgia Senate seats went Democratic right after the first of the year. So suddenly there was a Democratic majority, a slim Democratic majority.
The thinnest possible, 50 plus the vice president. Can't get thinner than that.
That's exactly right. So, there was just a lot of chatter about would Justice Breyer take this opportunity to step down and give President Biden his first opportunity to appoint a younger liberal to the court. And I had initially thought maybe he would, and then I was getting enough signals that he wasn't going to, that I felt pretty confident at the end of the term that he wasn't. But I wanted to go see him and understand that decision and make sure my sense of it was accurate. So I let the term end, and of course he didn't step down, and I felt pretty confident that he wasn't going to. But soon after that, in part because of smart people like you and others who thought, well, maybe once the dust settles, he might be interested in leaving. And several people thought that once the term is over and he's not worrying about his opinions, he'll start to think maybe this is an opportune time to leave. So I arranged to go up to New Hampshire to visit him in his summer place just north of Manchester. And I talked to him about a lot of things, and he was reluctant to go on the record for much, but he would go on the record for the open-endedness he felt about his decision. And he said he just hadn't decided yet. He did tell me what factors would play into it, his health, of course. He's quite a vigorous 83-year-old man with, as I said, kind of spring in his step still. And he's got a bunch of grandchildren who he lives with for a significant part of the year, either at their home in Cambridge or up in the summer place. So he's someone who doesn't seem to have slowed down at all. But he said he's also thinking about the institutional side of the court. So I felt like it was important to hear it from the horse's mouth, so to speak. And I took as much as I could get out of him at that time in July. And, frankly, to put my mind at ease that it wasn't going to happen this term. And he didn't say the following, but I actually think that he probably would seriously consider at the end of next term, because if we get to June of 2022, he will have had another year of impact and influence at the Supreme Court as the senior liberal justice. He talked a lot about that and how that was an important position for him. So I know he would like to have a full term as that. And it would also give him a little bit of time before the midterm elections in November, when the Senate could flip. So let's say, for purposes of argument, that he does leave at the end of June of 2022. Presumably, if nothing changes with this one vote majority the Democrats now have, President Biden will be able to name a successor of his choice.
Right. So let's turn to some of the issues before the court and kind of the recent swirl of controversy. I mean, the court's always, to some extent, controversial, but especially so at this moment. I think I would say the latest round of commentary flows from the court's decision not to block a Texas law that appears to bar abortions after 6 weeks. Now, the enforcement is not through the government, it's through private parties, and that seems to have had the framers' desired effect of limiting review. But people were surprised that the court didn't stop it, at least in an interim basis. What did you think?
I was somewhat surprised too, because I thought Chief Justice John Roberts is going to feel like Texas is gaming the system. And I thought that he would be able to persuade at least one more colleague on the conservative side to think that also, because they wrote this law with the precise effect to try to beat the system, the sponsors of it knew that, for better or for worse, it conflicted with Roe v. Wade, because under the 1973 precedent that made abortion legal nationwide, government cannot interfere with a woman's decision to end a pregnancy before viability. That is before the fetus can live outside of the womb. And that's usually at, 22, 24 weeks. Now this is a 6-week cutoff. So they knew it was unconstitutional, at least as things stand now. And for nearly 50 years, that has been the law. And I thought, as much as Chief Justice John Roberts has voted against abortion rights, that he would not like this kind of a law. And indeed, he ended up dissenting with the three remaining liberals on the bench. But the 5 justices in the majority, they essentially went along with the playbook from Texas and said, well, the abortion clinics that have brought this case, they might not have grounds to sue these officials and the state court judges and clerks who they're trying to sue here. And we just don't know. And so we're not going to intervene at this point. And the chief said, can't we just put this thing on a pause? Can't we just hold it? And the clinics that brought the case said, there will be harm to us and to women if you let this take effect. And the majority said, on balance, we don't think there will be any harm to you.
Right. So it was 5-4. It was 5-4 not to stay.
Not to intervene, which right. And they didn't write an opinion, but they did say that it looks like when you balance out the harms, there would not be sufficient harm for us to intervene.
So Chief Justice Roberts voted with the liberals, if you will, right. Breyer, Sotomayor, and Kagan. And you wrote a piece that said he's lost control of the court because he couldn't convince any of his conservative colleagues to join him.
I thought that was a very big deal. The chief, I just 1 month ago, I was on a similar, teleconference, and I argued that people shouldn't write off John Roberts. That, several of my colleagues have said, he's going to be irrelevant. He won't have the control he used to have. And I really felt like John Roberts is a winner. John Roberts is able to, get done what he wants done.
So he gets the job done.
Pardon me?
He gets the job done. He knows how to kind of engineer.
He does. And he was the youngest Chief Justice in history for 200 years. John Marshall was only younger than him. He's somebody who things tend to go his way. And I thought, John Roberts is a very persuasive individual. He argued 39 times in front of the Supreme Court. He's good at persuading people on the law. I was surprised that he couldn't get either Justice Kavanaugh or Justice Barrett to come over, especially get Justice Kavanaugh, who has seemed to show some ambivalence in terms of joining with Roberts on some things that could be liberal conservative litmus tests, but he couldn't. And so, Ron, the two things that got me interested in saying that he had lost control was, one is that he lost that case, but also that it was such a huge issue. This was not a B-grade issue. This was right. A huge issue. And
public attention naturally focused on the court. And what does this mean for the future? And not just reproductive rights, but other issues. Let me echo what my colleague Christine Stutz has said in the chat. Audience members, please feel free to ask questions in the Q&A. We've got Markeisha here ready to field those questions. So we invite you to join the discussion. But I'll continue for the moment. Joan, so people say, well, if they're willing to let this plainly unconstitutional law, I say plainly meaning under the precedents of Roe and Casey and other cases, if they're willing to let this go forward, what else are they willing to do? And it's against the backdrop of other decisions, notably the court's decision in the voting rights cases, where they appear to really blow a hole in the Voting Rights Act, first in the Shelby County case a couple of years ago, and then more recently in looking at Section 2 of the Voting Rights Amendment. So commentators, like my dean colleague, Erwin Chemerinsky from University of California, Berkeley Law School, published an op-ed in the Los Angeles Times. The title of the op-ed, I don't think this was Dean Chemerinsky's words, but the title was, "Are Supreme Court Justices Partisan Hacks? All the evidence says yes." My guess is that Dean Chemerinsky would rather that was not the title. But his point was, this is a pretty aggressive court, and he and others are questioning whether the court is on the level. And we see that kind of questioning going on. Our colleague at the University of Baltimore, Professor Emeritus Garrett Epps, reviewed Justice Breyers' recent book, saying that it had an unrealistic view of the current court. You reviewed Justice Breyers' book and said it had a rosy view and that Justice Breyer may be naive here. Is the court on the level? I mean, what's happening here?
Well, you know that phrase partisan hacks that got your attention in that headline? That was the phrase that Amy Coney Barrett used last week when she was speaking at the Mitch McConnell Center at the University of Louisville, where she said, the media misportray our decisions and we're not a group of partisan hacks. There was, it was sort of unusual that she would say that just after Mitch McConnell who sped through her confirmation.
I'm old enough. You'll appreciate this reference. I remember Richard Nixon saying, "I am not a crook," and everybody thought, "Okay, he's a crook."
Yeah,
so,
a little bit
if you
of the lady
protest too much. Exactly.
Yeah. So that's probably where that phrase in that LA Times piece came from. I think the justices are feeling defensive about that. Justice Breyer is a very earnest, sincere justice. He's very serious. He's been around for 27 years. He felt like he had a message about the court not being partisan. His timing is not so great, as he himself acknowledged just last week in another interview. For him to be talking about how they're not partisan or not political, and in the wake of two orders before the Texas abortion case, in which the court, again by conservative liberal votes, party line votes, rejected two Biden initiatives, one, the eviction moratorium tied to COVID-19, and the other, new U.S. asylum policy. A Texas judge had said that the Biden administration did not have authority to roll back Trump asylum policy and said that the Biden administration has to revive the Trump policy. So these decisions look awfully political. And I think that the commentary is rightfully at least calling attention to them. And these justices are saying, no, you just don't understand.
Yeah, well, we'll see who wins that battle of public opinion. But the justices do. I mean, they're clearly defensive. I mean, they're literally rushing to the defense of the court. So what's changed to bring about this moment where we're questioning, or some are questioning, the court's legitimacy? Is it the nature of the confirmation process? Is it the people who are being appointed? What do you think is different now?
I would say it's a combination of things. Until 2010, there was variety between the party that a justice came from and his or her ideology. But starting in 2010, when Justice John Paul Stevens, who was a Republican appointee of Gerald Ford, stepped down, suddenly we had only the Republican appointees being on the conservative side and the Democratic appointees being on the liberal side. He was succeeded by Obama appointee Elena Kagan. And that kind of neat political ideological alignment became just so much more obvious to people. So that's one factor that happened. The other factor has been the great success of the Federalist Society and conservative Republicans who have worked very hard to get certain people onto the bench. There was the mantra back from our era, as you remember, no more suitors. David Souter, who was appointed and nominated by George H.W. Bush back in 1990, who pretty quickly became a member of the liberal wing, just angered so many conservatives who felt like he wasn't as advertised, and he was advertised as a home run for conservatives. So that became a real disappointment, and they worked very hard to make sure they were choosing individuals who would produce the kind of agenda they wanted. And Donald Trump, back in October of 2016, while he was on the stump, said, I am going to appoint only justices who will reverse Roe v. Wade. And what's going to happen once I get all my justices on the court? It will be reversed. And his phrase was automatically. It's going to go back to the states.
And he also spoke of just what you said. He said my justices. He spoke of his justices.
I know. And I remember at the time thinking, oh, that can't happen that quickly, or it's not going to happen. And well, look where we are at this moment.
Yeah. Now, but I want to come back to the confirmation process, because you're right that there's this effort, especially I think on the right, to identify justices who are going to be true blue, true whatever. But how does that happen in the Senate? So in your biography of Chief Justice Roberts, you tell a story that I helped you tell, that when Roberts was nominated, there was consultation with the minority party, then the Democrats. This was President George W. Bush, who was in a position to appoint. And he consulted with my former boss, Senator Reid and Senator Leahy and others. The Democratic senators indicated that there were some senators whom they would filibuster and others who they wouldn't. And Roberts was one who wouldn't be filibustered. And he wasn't. In fact, he got about half of the Democratic votes at that time. So it was a process in which the minority had a say in who would go on the court. And we ended up in that instance with John Roberts, who at least for the moment seems to be, more of a moderate. That changed. Democrats changed the rules for considering nominees to the lower courts in 2013. Mitch McConnell then changed the rule for the Supreme Court. Republicans changed the rule in 2017, and that led to the party line confirmation of Justices Gorsuch, Kavanaugh, and Barrett. It's different, isn't it, if only one party is choosing the justice?
Right. There's nothing that the minority party can do anymore because of there is no filibuster. So when Ruth Bader Ginsburg died almost a year ago to today, it was September 18th, 2 days ago, when she died, within days, Donald Trump could offer the position to Amy Coney Barrett. He could make that public a few days later. And Mitch McConnell, then majority leader, could speed it through and she could take her seat on October 26th. And there was nothing that Democrats could do about it.
Yeah. So that, by definition, it's going to lead to more partisan justices if only one party is voting to confirm them. And the perception is that, and now the question is, would a Republican-controlled Senate, if the Democrats lose their majority, would they ever confirm a Democratic nominee? And Mitch McConnell has raised that question.
Mitch McConnell has said that at least this is another reason why Justice Breyer probably will leave before those midterm elections, because he might not. Who knows? Justice John Paul Stevens stayed on until he was 90 years old, and Justice Breyer is a spring chicken at 83, I guess. Right. Yeah, that's right. So, but Mitch McConnell has already said that if he becomes majority leader again, there is some question about whether anyone would be confirmed in a presidential year, which would be 2024, of course, but even maybe before then, which would be 2023. He's left that an open question.
Yeah. Again, I encourage our audience to join the discussion. There were just a couple of questions in there. Markeisha, do you want to pick one out and help or the audience communicate, speak with Joan?
Sure. Thank you, Dean Weich, and thank you again, Ms. Biskupic, for your time today. We do have a few questions. The first is, given the concerns about the perception of the court, do you think it's time to reform the court?
That's such an important question, and such an important question that President Biden has appointed this commission to look at that. And the reason he appointed it was because he was trying to duck the court packing issue. Back in October of 2020, when he was running, there was a lot of liberal pressure on him to say whether he would want to expand the number of seats beyond the 9. That is something that Congress can do under the Constitution. Congress has the authority to set the number of seats. It's been at a low of 5 and a high of 10, but for 152-ish years, it's been set at 9. And President Biden, who's said he's not much of a fan of court packing, decided in the alternative he would vow to appoint a commission if he won the presidency. So he has this very prestigious group of people who are studying all sorts of reforms, including court expansion, including term limits, including things for increased transparency and ethics. But to tell you the truth, I have not seen sufficient interest in court expansion. First of all, the president doesn't really want it. It doesn't seem like there's a majority of the senators who want it. Majority of Congress, I should say, not just the Senate. So I think if there's going to be reform, it's going to be of a different nature. Maybe issues of transparency. Term limits is something that a lot of people would have talked about. And I think
didn't Justice Breyer kind of endorse term limits?
Yes, once upon a time he did endorse the notion of like 18-year term limits, but now that he's nearing 10 years beyond that, he's not as vigorously endorsing it. But some of the justices have in the past, and it makes some sense. It's just that how do you get it going in a practical vein? Right. And there's a question, wait a minute, I should make sure the audience knows there's a very real question about whether the Constitution would have to be amended for that. And in fact, Dean Chemerinsky and many others who have studied the question believe that it would take indeed a constitutional amendment, because in our Constitution, Article 3 judges are appointed for life.
Right. And this swirl of discussion about, reforms to the court, I think really started maybe the combination of President Obama's nomination of Merrick Garland not being considered by the Senate. And then, as you described, Joan, President Trump's nomination of now Justice Barrett really coming through at the very end as people are voting in 2020. I mean, has that just fundamentally changed the court? Is there a sense that the composition of the court is no longer on the level, as I said, that somehow it's become a partisan tool?
Yeah, no, I think that's definitely in the atmosphere. And that's what gets right now. It's mainly liberals ginned up that way. But Justice Breyer in his book referred to polls that had appeared to show public support for the court kind of in a steady mode, but it's actually dropped off in the last year. Now, I'm not sure polls tell you much sometimes, because people can't even name all 9 justices, maybe not even the majority of the justices, but it just goes to show that public confidence is probably waning. Is it seriously waning? I don't know, but I think enough of the justices are concerned about it.
Yeah, well, let's come back to that back and forth, but I'll open it to Markeisha again. If you see a question in the chat that would be good to pose here.
Yes, this is kind of following up on the last question. And let me know if you feel like you've answered this already, but the question is, are we at a point where additional judges should be appointed to balance the court, to mirror public opinion?
And that is exactly what some advocacy groups are pushing. They feel like the balance we've got now, 6-3, with conservatives who are actually more conservative than their predecessors. So this is what's kind of gotten people going, is that when the certain candidates for the court are handpicked and scrutinized in a way where critics think they're put on there not to actually just really decide cases in a neutral way, but to produce certain outcomes for presidents and their political parties. That's what's gotten the concerns going. So the folks in favor of court expansion would add, maybe 3 or 4 seats. But then what the critics say is, well, how do you stop? How does that even stop? And why do you even need to do that? And wouldn't that actually further diminish public confidence in the court? Because it would then cast the court as much more of a political entity. And this all harkens back to the 1930s, when Franklin Roosevelt really was unhappy with rulings that he was getting from the court and proposed adding a new justice for every justice who was over age 70, which would have meant 6 new justices at the time. And that failed in every way. But in some ways, he won, because the court, the 9 old men, as they were kind of called at the time, some of them retired, and FDR was able to appoint essentially a whole new court.
Right. Now, the defense that Justice Breyer and others, some commentators offer to this line of criticism is that you're not looking at the full picture. If you look at the full range of cases before the court, you see many unanimous decisions or, unusual alignments of justices. So it doesn't necessarily follow the narrative that maybe the popular press advances, that this is a 6-3 court, it's all the conservatives against all the liberals. Do you see any merit to that line of argument, that if we look at all of the cases, we see something different?
Oh, yeah, of course. If you look at all the cases, just every single case, the majority are by much wider votes, either unanimous or 8-1 or 7-2. But which cases really matter? Like, you could say in any given term, you might have, let's just take what's just happened right now. Coming out of last term, there were plenty of unanimous cases. There were plenty of ones that had unusual lineups. But what really mattered, like the voting rights case, that constricted the protections of the 1965 Voting Rights Act. That was 6-3. The case Cedar Point, I think it was Cedar Point. Yeah, the one I always think Cedar Grove, Cedar Point. It was the union organizing one from California, where again 6-3 that diminished union organizer rights on agriculture property. Kind of a core, litmus test kind of issue. Another one was the disclosure of contributions. They were for nonprofits, that could be extended to the campaign finance venue. So, those cases are cases that go to the heart of democracy. And that's what I would say about, the partisan gerrymandering case of 2 years ago that was 5-4, again, right down the line, a political lineup that said that judges couldn't look at excessive partisan gerrymanders. Right. So you take all these cases that are divided along party lines, ideological lines, that really go to the core of democracy. Those just feel like they're weightier. The abortion case feels weightier, is weightier. The gun rights kinds of cases, the 5-4 Heller case. So that's my point, is that all these cases aren't created equal.
I'll play Justice Roberts here, Chief Justice Roberts, and say, but look, this is Roberts. He said, I decided to uphold the Affordable Care Act. How about that? Didn't you want that? And I gave you that. and then my colleague, Justice Gorsuch, held that Title VII of the Civil Rights Act covers sexual orientation. You didn't expect that, did you? And then we all, not all of us, but I guess it was a somewhat unusual alignment that pushed back on President Trump, for example, on the census question, whether immigration status could be asked in the census and whether Trump would have to give up his taxes. And that's complicated in a complicated procedural posture. But there were decisions that, to use your phrase, Joan, counted, were weighty, that came out the way progressives might like, no?
That's absolutely right. And I would not, I spent a lot of time in my book on the chief researching just how he switched a couple different votes to come out that way in favor of Obamacare, as it's now called by both sides. And that was a very hard choice for him. It angered his colleagues. They felt, his conservative colleagues, they felt a very strong sense of betrayal. But that decision won the chief a lot of regard in the public because he did look like he would not be so partisan. And I would say, yes, that is Exhibit A, and Justice Breyer refers to it in his book. And what I said in the review in the Washington Post was that he's absolutely right, but that is an exception. That is not the rule. And then on Justice Gorsuch, again, you're absolutely right that Justice Gorsuch cast a vote and wrote the opinion to extend job discrimination protections based on sex to gay and transgender workers in a really important case called Bostock from 2020. And that, some of us thought maybe there was a chance he would go that way just because of his textualist approach. And that's why he did go that way, the way he read Title VII. So I would say, yes, that's a perfect example of an incredibly important case in which someone who is a Trump appointee who generally votes for conservative outcomes cast a vote based on his methodology that had what a lot of people would regard as a liberal outcome. So yes,
it happens.
I don't discount that at all.
You mentioned earlier in our discussion that the people talking about the transparency of the court. And of course, one of the most obvious ways in which the court is not transparent is that cameras are not permitted in the Supreme Court chamber. We had an audio feed of the cases during the pandemic, but now the court returns to the majestic building and you and other journalists are there. Some members of the public get in, but not cameras so that the rest of us can watch the argument. Do you favor cameras in the courtroom? Would that make a difference in how the court is perceived, how they act?
I've never been outspoken about cameras in the courtroom. I have been outspoken about the need for more transparency and to tell us more about their processes, their rules. The whole thing is shrouded in a way, from things as simple as the fact that Amy Coney Barrett gave that speech at the University of Louisville, and did not allow people to tape it or to televise it or gave any advance notice. And I thought she had an important message to tell, and it would have been good to get it directly from her than to have to rely on the local report of somebody who wasn't able to produce a tape just because of the ground rules there. And then another thing I've really felt is important for advocacy before the court. There are a lot of very subtle rules that are not actually made public, but the justices have. And advocates, even some of the experienced advocates, will argue that puts so many people, so many litigants at a disadvantage because they don't know about various moves that lawyers don't know about various moves they can take that might enhance their case, might be able to buy more time and serve their clients, whereas the regular practitioners, that the general atmosphere at the court favors, just is has a sense of unfairness, I think. So I'm just in favor of more transparency. Cameras in the courtroom, I think, would be great for people. I don't think it would be a bad. But I don't like to go around advocating that for some reason. I just think they should just be more open, and cameras would help that.
Mm-hmm. Markeisha, other questions in the chat that you think would be worthwhile here?
Yes. Thank you, Dean Weich. We have a really good one that just came up. So the question is, when do we actually break democracy by not upholding rights for women, religious minorities, LGBTQIA plus people, and people of color? What case tips us into a non-democratic state of existence?
Wow, that's a profound one. Joan, you want to?
That really is. And that's a great question, because do we feel something's slipping away, or does it take a big bang? What is that? And, all three branches of government are responsible for democracy. And, some people would argue that, Congress has fallen down on the job, and we obviously have had trouble in the executive branch. And where does the Supreme Court and the judiciary at large, how does it pick up the slack? And I have to say to the student who wrote that very important question, there are justices on this court who feel like they're playing their proper hand in democracy right now. Certainly the conservative majority isn't thinking that it's throwing something away. It thinks it's standing for something, and that it's preserving democracy. So in some ways it's in the eye of the beholder. But I think that is something we all have to ask ourselves: is there a tide that's turning here, and are we feeling it now, or will we not understand what has happened until it's too late?
Yeah. Wow. Great question. Great answer. I have to come back to one issue of transparency and judicial ethics. I was surprised to learn in preparing for this webinar that Justice Barrett has a $2 million book deal. Isn't that amazing? I mean, I'm just saying.
Okay. And here's something about that. So, some months ago, Politico reports that she has signed a $2 million book contract with, I think it's a subsidiary of Random House. It's a conservative imprint of Random House that like Mike Lee and Ted Cruz have published on. And Politico writes this, and the rest of us follow up and think, whoa, $2 million contract? And this was, she was hardly on the court for a couple of months before this happened. Right. And what happens is we get word from the Public Information Office, Justice Barrett is saying nothing about this. We're not telling you anything about it. We're not telling you a thing about it. So several of my colleagues who cover the court on a daily basis, checked in with the publisher, who acknowledged that they had a contract with her. They did not, they would not say what the topic was. Politico had reported that it was going to be something about how justices don't let their personal views get in the way of their cases. But for $2 million, I mean, really? What else are you going to say? She's got to be, there must have been something else that was proposed here, because we just don't give somebody a $2 million contract for, stating the obvious. Right. And she does have a really interesting personal story. She's a very interesting jurist here.
Yeah, tell us, give us your early sense of her. You've obviously read these justices.
She's been quite cautious until this summer when she voted. She obviously voted with her conservative brethren in a way that felt sending a pretty strong message. And she's also sent a strong message in her lack of transparency in terms of, have you signed a contract? What is it? What is that all about? Just tell us something. Tell us when you're going to be giving public speeches because we'd like to go. And she says, the media gets it all wrong. Well, give the media a chance to get it right, because people, I have to say from where I sit, I want to hear from them firsthand. I don't want to have to take my information from others. That's my baseline. I do not want to have to learn about anything from another reporter. I want to be there.
Of course.
So, but she was a little bit cautious in one of the religion cases, not joining in the Fulton foster parent case, but she didn't write much. She wrote very few opinions last session. So we need some more data points. We just need to know a lot more. And that's something I'm very much looking forward to in this new term.
Yeah.
Understanding more about her.
Be interesting to see where President Biden goes if he gets appointments. Would he look to the Court of Appeals, as recent presidents have? You and I know that Senator Leahy, each time there's a Supreme Court vacancy, he makes the point that a president should look outside the judicial monastery for nominees. Can you envision someone coming to the court? No, Justice Kagan, of course, had not been a judge before, right. But she's like a unicorn. That hasn't happened in a long time, right?
No, and I don't think it's going to happen this time. I think that the person most logically on deck happens to be a former law clerk to Justice Breyer, and she's an appeals court judge right now on the very powerful D.C. Circuit. It's Judge Ketanji Brown Jackson, who is, as I said, she was a former Breyer clerk. She's got terrific credentials, and she was just elevated by President Biden from the district court of here in the District of Columbia to the appeals court. So.
This does feel a little bit like it's a little bit incestuous, isn't it? That all these former clerks get appointed as justices. I think it's true of Kavanaugh, Roberts, not Barrett, I don't think, or did she?
Barrett was a law clerk.
So they all. So right. So it's the only way you get is when you become a clerk, or you like automatically in the pipeline?
Well, listen to this, and I this is something that I think is a really big deal. For a while, everyone was saying, "Oh, they all have these Ivy League credentials," but that's nothing. What they have are these former clerkships, including Justice Breyer, who clerked for Goldberg, as you probably remember, Ron. So Justice.
Well, wait a minute. I don't remember Justice Goldberg so well, but yes, I take your point. Yes.
Maybe I'm slightly older than you. Okay. Justice Goldberg, who served for only a couple of years because LBJ twisted his arm and got him to step down. Okay. So, but Justice Breyer is a former law clerk. The chief is a former law clerk to then Associate Justice William Rehnquist. Gorsuch was a law clerk to Kennedy and Byron White. Brett Kavanaugh, of course, was a law clerk to Justice Kennedy. Elena Kagan was a law clerk to Thurgood
Justice Marshall.
Yeah. So right now, the only ones who were not law clerks, Sonia Sotomayor was not. Justice, and then let's see, who else do we have? Oh, Sam Alito was not a law clerk to a Supreme Court justice.
Now, the only thing I'll say, I have to bring in a little University of Baltimore here. Many of our students serve as clerks in the Maryland judiciary, including on the Maryland Court of Appeals, which is our highest court. And I don't know if it's coincidence or not, but more than a third of the judges in Maryland are University of Baltimore graduates. So there is, that clerkship path can be a very, I don't want to say profitable, that's not the word I'm looking for, but, a very promising path for
That's right. And I just want to add one amendment. Clarence Thomas is another of the justices who was not a law clerk. And he will often tout the fact that he's always looking for non-traditional law clerks. He's not looking for someone who's been completely on the same path as everyone else, and he likes to go for people from state schools.
Interesting. Markeisha, back to you, if we have other good questions from the chat.
Yes, we have a few. So we talked about the voting rights case earlier. So this one's in reference to voting rights. Do you think the court was right to end preclearance under the Voting Rights Act?
That's the Shelby County case.
That was really a blow back in 2013 to say that this law that had been reauthorized so many times, signed by President W. Bush in one of the reauthorizations, and that had proven so effective, no longer needed to be in existence. That was sort of the basis of Chief Justice John Roberts' opinion, is that, things had changed in the country. This isn't needed anymore. But as soon as that opinion happened, Texas and North Carolina changed laws that under the old system would have needed preclearance and probably would have been disapproved. So it has really changed the landscape of voting rights.
Yep. And then more recently, they interpreted Section 2 of the Voting Rights Act in a way that limited that provision. And so the act itself is really on its knees. All right, Joan, we're going to put on your predictive cap here and tell us what's going to happen to the right to abortion in Roe. Not only is the Texas law sitting out there, we'll see how that goes, but then the court has before it on the docket a Mississippi case, as you said, that would severely limit the right to abortion in the way that we understood that right under Roe and Casey. Are the conservatives ready to act?
I think the conservatives are ready to act. It's just a question of how far they roll things back. In the Mississippi case that will be argued on December 1st, they just announced the date today, what's in dispute there is a ban at 15 weeks, which again would be under the viability line, which had been the line separating when government could interfere with a woman's choice through Roe and through the 1992 Casey affirmation of Roe. And I think that you have a majority that's ready to at least dissolve that line of viability. And how far they'll go to essentially turn everything back to the states, I just can't predict right now. But I think we're in for a major, I think no matter what, we're going to have a watershed decision.
And to what extent are the justices looking at the political fallout from that decision or other decisions? There are some people who say that would be disastrous for Republicans.
I used to repeat that line because I used to think John Roberts, of all people, who's very shrewd about politics, would think that voting to reverse Roe or at least undercut it seriously would give Republicans such a great issue, and that he would understand that because he came up through politics in the Reagan administration. He gets the political side of the law. But I don't know if that former conventional wisdom really holds anymore. And just look what happened now. Just look at Texas. Effectively doesn't have the coverage of Roe v. Wade right now. It just doesn't because of the court's failure to intervene. And that's you hear people talk about it, but you don't have people marching in the streets. And I just wonder, even if we were already in the midterm elections, how much it could make a difference for Republicans at that time. Now, it might spill over. Democrats really would like to take advantage of this, but we'll have to see if that happens.
Yeah. Markeisha, any last questions? If there's time for one more as we wrap up here.
Yes, I have a good one. All right, so here we go. This question is focused on the recent comments by Justice Barrett and Justice Thomas that claim that the Supreme Court of the United States is not partisan or political. However, from time and again, we see that the SCOTUS decisions often fall upon the party lines of the presidents who appointed them. What is your opinion on those justices' recent claims that the court is not partisan or political? Is it ever possible to have a nonpartisan court, since justices will always come to the bench with their own personal histories that inevitably impact the way they interpret the laws? How do we reckon with that?
I love that question because it really gets us to summation of this whole session. Joan, where are we headed?
That's right.
This court?
And what I would say is it didn't used to be that way. Byron White, who was appointed by John F. Kennedy, ended up being much more conservative. David Souter and John Paul Stevens, both appointed by Republicans, were offered a real amalgam of decisions over the years. They both ended up being more liberal in the end, in part because the court was changing. But what we've got now is such a strong partisan alignment that's what makes it so distinctive, is that it does break what happened in earlier eras. And I think part of it is just because of the way people are screened now for these positions. So I think they wouldn't be saying that they're not partisan if that wasn't something that concerned them and they would feel defensive about. It doesn't,
but then,
it's not just a commentary.
It's not just commentary, but then you referenced earlier the history of the Supreme Court in the early Franklin Roosevelt years, striking down laws passed in the New Deal, and the pressure from President Roosevelt and the public kind of caused a change. Some of the justices adjusted their positions in maybe to preserve the court's role in the face of this kind of significant criticism. Might this court tack towards the center in the face of all this criticism?
Well, I think Chief Justice John Roberts certainly has. And I think if he weren't chief, I think being Chief Justice, he has so much at stake in this court that informally bears his name. And he has said in some settings that before this year, that if he were an associate justice, which is what he was appointed to initially before Chief Justice Rehnquist died in 2005, he was initially appointed to succeed Sandra Day O'Connor. But if he were an associate justice, he said he probably wouldn't be voting exactly the way he votes as chief, because he's got more institutional interests. And I think those institutional interests go exactly to your point, that he wants to preserve the integrity of the court.
And what's, Joan, where are you headed now? You've got, 5 more justices you could do biographies of. What's your next project?
Yeah, I've kind of taken the really interesting ones already, though. But I'm looking at a broader group portrait of the court, starting with the Trump years, to see the Trump effect on the court from the Trump years into the Biden years, because obviously the court has changed significantly in this time. And I want to look at it from kind of the dynamics on the inside. Interesting.
So maybe a group biography as they interact with each other. Very interesting.
Right.
And in a sense, a biography of the court itself. All right. Well, we are at the hour when we conclude this program. I thank, first of all, Markeisha Dobson for joining us and screening the questions. Joan Biskupic, thank you so much for joining us. I wish we were live. We didn't comment on the fact that this would traditionally, in the old days, have been a session in our building or a fabulous law center. Someday we'll get you up to Baltimore. You've been up here, actually. You spoke in Garrett Epps's class, haven't you?
Yeah.
We'll get you back. We'll get you back here. And in the meantime, we thank you very much for joining us on Zoom. Thank our audience members for participating. And we will see you as this court term unfolds and as this major issue in our democracy unfolds. So thank you all very much and good evening.